The next case is Ellen Douglas versus Jeffrey Raymond. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your arguments. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honor. If it pleases the court. I don't anticipate doing any rebuttal. I anticipate making this very short. We are here to present oral argument. I am, of course, the appellant. There are two children which are the subject of this appeal, both having the initials of ER. Suffice it to say that we are dealing with a 6-year-old and a boy and a 10-year-old girl. So our arguments, I think we raised 4 points. One was that the trial court abused discretion modifying the shared parenting plan, specifically not modifying it, but in the terms of what they did, by reducing dad's midweek time from twice a week to once a week, requiring the visitation in Summit County or 30 minutes from mom. And also, I would note that that was contrary to what Family Court Services recommended, not in accordance with dad's wishes, and we believe not in accordance with the children's wishes, according to the transcript, what the child had expressed to mom and certainly to father as well. The second point, and again under 3109.04E2, which governs modifications of shared parenting plans, the court did find a change of circumstance in the children and parents. We're not necessarily arguing that, but when you go to the best interest, the reduction in the parenting time is what caused issue for us. Okay. Family Court Services did note that the parties did have a plan in place. She did note that she thought that if they lived 25 minutes or part of 50-50 plan would be great. And I understand, I think we all understand that adding distance or long distance to parenting orders doesn't make anything easier for anybody. I always tell people, the closer you can live together, the easier your life is going to be. That's just a simple, basic fact of any of these plans. Number two, obviously the court has the power and did to modify a plan in the child's best interest under the 3109E2B standard. And of course, the court looked at the best interest test. But what we're again arguing over is that we don't believe that reducing the parenting time between dad and the two children was in their best interest at all. It definitely bonded to the kids, and we believe that the status quo should have been maintained there. As to travel, the second assignment was dad providing all travel times or transportations for these extra extended visits, which usually sent or take place around banking holidays or President's Day or Martin Luther King Day, et cetera, and so forth. It's a great time to use those holidays, but to require him to do all the transportation, we thought was an abuse of discretion, especially since most...
How many banking holidays did the court? They only 3.
I think it was 3, yes.
Yeah, so it didn't do all the national holidays, for instance.
No, they selected 3, that fell where it seemed to be logical to work with dad's schedule. And we're not arguing over that, that was not an issue, but it's just the transportation. And the other thing is mom testified she'd be willing to do part of the travel. Mom also testified that her boyfriend would be willing to help out and had helped out. So to stick that all on dad under those circumstances, we respectfully felt was an abuse of discretion and not necessarily.
Did the court just say that dad is responsible for travel?
Yeah, right.
So there's nothing to necessarily prevent the parties from agreeing that mom...
Correct, Your Honor. However, as the court knows, human nature being what it is, unless it's written in there and I have to do it, unless I'm a virtuous saint, which I haven't seen too many of, that usually isn't likely to happen. I wish it did, but in my practice, I haven't seen it, I wish. And then he wanted to be named residential parent for school purposes. I did note that one of the issues we had on the abuse of discretion standards, the kids don't and never did attend school in Mom's district. Now, we recognize and acknowledge that's the way it's always been. They lived in Cuyahoga Falls at the time and went to Stowe District, which did have open enrollment. However, Dad went out of his way to check the schools down where he is, and the schools are good, and also there was proper either latchkey or daycare and other swimming programs, which is just as easily accessible and good for the kids as what Mom had and should have been considered. The kids were not, Family Court Services didn't interview the kids. There was no in-camera of the kids. Now, albeit, I don't think we requested one, but Family Court Services could have easily interviewed the kids, which didn't happen. We felt that should have happened. Also, paternal grandmother noted, and gets along with maternal grandmother, which is a good thing that the grandmothers work together, is that she's getting older, and the kids would come to her, and maternal grandmother's at 6:15 in the morning, and then she'd take them, then she'd take them to Stowe, then she'd pick them up after school and take them back. So one of the arguments was it was too long to be in the car for travel. But if you look at all the cumulative time the kids were in the car, I really didn't see that, when I mapped out from, say, Akron or Cuyahoga Falls to Youngstown versus going back and forth in the course, that it really didn't look to me as bad as what I see in normal schedules for kids. Didn't look to me to be a horribly burdensome or out of the way thing. Last but not least is the modification of support. And I looked at that, and obviously the court usually doesn't change things unless there's a 10% difference in the net amount of support. Now, the court did take and factored in some deviation factors, but it's still, when they got done with that, the net figure was about $72 difference. It wasn't over 10%, which would have been, I think, over $90. So we thought that was a mistake. Also, Dad had testified a couple things that he had borrowed $12,000 from his own mother to meet expenses. And it should also be noted, which is not part of this argument, but just by way of background, when these folks divorced, Dad gave Mom the house in Cuyahoga Falls. Didn't get any equity, gave it to her, which required him to then go get his own place, and that was part of what cost him the money, because he didn't have any equity to work. He's not complaining about it, he did it happily, but that was a known factor. He was also working when he lived in the Falls in the same place that he's working now, so that's not an unknown factor that the parties had. So that's the sum and substance of our objections. Thank you very much. Do you need some water?
I have water for this. I'm draining, sorry about that. May it please the court, my name is Leslie Grasky, and I'm here on behalf of Ellen Douglas, the mother in this matter. I believe that a thorough review of the record will show that the trial court did not abuse its discretion in its allocation of parental rights and responsibilities. Sorry. The original order was reached by agreement. It's a dissolution. Mothers stayed in the area that they had always lived in. They had agreed to Stowe as the school, and Dad then moved to Youngstown and then relocated to Boardman, which I believe is a little bit closer. It's not an abuse of discretion for the court to find that 2 hours of travel time twice a week is too much for little kids, especially since there was some evidence that father had not assisted the party's daughter with schoolwork, and she has ADHD and has focus issues. So now we're adding 2 hours of travel time to someone who was not helping with schoolwork. In a perfect world, yes, the parents would live closer and share their time 50-50, but the person who was in control of that not being the perfect world is father, who moved to Boardman, and his mother, who moved outside of the Akron area, which made it impossible for Dad to come and spend reasonable time with the children without the children riding in a car for 2 hours. Once per month, sorry, taking that one time per week away is not inappropriate under the circumstances. The Family Court Services evaluated and the court adopted the recommendation that dad have the bonus weekends, like in-service weekends, parent-teacher, extra days off, and he could have those weekends, but in exchange, he would provide the transportation both ways. This only occurs about 3 times a year, and it's not unreasonable if he's going to get that bonus time, that he provide transportation both ways.
Well, their 3-day weekend's a lot more than 3 times a year.
Well, the weekends that were allocated to him separately are about 3 times a year.
Right, and so what I'm saying is then mom gets the rest of the 3-day weekends?
They alternate them under the standard order. I'm sorry, I'm glad that you raised that issue, because the standard order gives half of the normal weekends, Martin Luther King Day, President's Day, Memorial Day, Labor Day, those kind of days are allocated equally. These days that are not on the court's standard order, like in-service days, etc., are given to dad. He gets those weekends if they align with his weekend. And those few times he has to provide the transportation both ways. Yes, this probably could have been worked out, but it didn't. And so we look at what the court did, and it's not an abuse of discretion. This court is very familiar with the high standard of an abuse of discretion. As to the school, the parties agreed the children would attend STO, which they could do through open enrollment, where the maternal grandmother lived and she provided the before and after assistance. They're still in that school system. There's no justification for removing them. Father presented no evidence that his Boardman schools were superior. He said that the neighborhood was superior because there are no sidewalks where mother lives. It is not an abuse of discretion for the trial court to keep the children stable in the only school district where they had attended. There are maternal family members there who can cushion the before and after time and avoid having the children in the care of. Actually, the Family Court Services evaluator used the word strangers, but not in daycare. This is family members taking care of the little cushion, not third parties. It may not be what this court would do, but it's not an abuse of discretion to keep the kids in the same school. Finally, the contempt issue is the 4th assignment of error. Father was ordered to pay for a share of work-related daycare. If he didn't like that order occurred about 2 years ago now, and he should have objected to or not agreed to and appealed that order. But that order is the order which was in place. Mother presented her statement of her expenses. She testified, she gave him the bills, and he refused to pay. He presented no evidence of payment. It is not an abuse of discretion under those circumstances to find him in contempt. We would ask that the court affirm the judgment of the trial court. If there are any questions, I'm available. Thank you for your attention. Thank you.
You have 5 minutes if you'd like it for rebuttal.
Just take a few things.
I think just by way of background, and maybe this does stem from the fact that when these folks did their dissolution, this was a quote, do it yourself. I've always told people, you think you're saving money, you end up spending more money with us fixing what you didn't do right the first time. So by way of background, they had an order where there was no child support exchanged and their parenting plan and everything was good. So the hardship for dad, just the court's aware, came when there was an issue with quote Children's checkbook and mom changing a daycare provider and not telling him, and he ended up having to pay expenses. We thought that's the order, we're not arguing with that, but just by way of background. Again, no matter what he's done, I feel it's an abuse of discretion to say, I can't afford it, I've given her the house, I had to have a mortgage, I've done this, I've done all the transport up until recently, to the last time he complained, the gas expenses, everything, he has done everything. and he's really strapped right now. So to sit, and find him in contempt after what he spelled out for the court, I do think is an abuse of discretion. And I do think that the order, if anything, should have been modified more downward than what the court did. It was a compelling equitable factors. This is not a guy he pays his support. This is not a guy that doesn't do that. They were arguing over the daycare expenses, but he's just working very hard, working his extra military stuff to try to catch up with things. And it's now since 2020, 5 years later, and he hasn't been able to do it. And frankly, I haven't seen any signs of him going out and being inappropriate in spending or buying things to where I can say to him, it's your own fault, don't come whining to us, because I have no problem telling people if they're not doing the right thing. We're not going to come here and ask this court for the court below to go fix something that they broke themselves. I won't do it.
Counsel, in regard to the contempt hearing,
Yes.
was there
ma'am.
evidence presented on impossibility of performance by the appellant?
Yes, he did. And he also had his mother testify as to basically she was financing the shortfall so that it really took that village to do it. He took the mother, took him, and really it shouldn't take a grandmother to finance this stuff. It's one thing to be a grandmother and help. We all know there's a big difference in helping your son who's making decent money, trying to maintain a house, trying to travel and do all these things, and he's just drowning. Is really why we're here, because I'm drowning, is what he tells me, and I believe him. Thank you. Appreciate the time.
Thank you both for your presentations. This court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and also the opinions are on the Ohio Supreme Court website. Thank you again.
Thank you.